All right, so if you're like me and you follow the Supreme Court through the news, you're going to see a bevy of headlines right now about this cybercrime, cyber hacking case called Van Buren. Now, none of those headlines are going to focus really heavily on what was actually at play in this case. What they're instead going to focus on is a split between the conservative justices. The three new justices appointed by Donald Trump disagreed with his regime's interpretation of the statute, and they sided with the liberal justices, leaving the old conservative justices in the dust, and they properly defended an overly expansive interpretation of a federal law that would have seen everybody in a gulag for accessing their Facebook pages. These are the types of outlandish headlines you're going to see. What you're not going to see, at least not what I've seen, is a robust discussion about why there is an ideological split on the conservative side of this argument. What you're not really seeing is whether the conduct at issue should be criminal or shouldn't, whether the conduct at issue actually encompasses something like checking sports scores or checking Facebook, and whether or not this is the end of the conservative lockstep approach to all of this. So I'm going to take a little bit of a different approach than some of the other analysis you may have seen, and I'm going to walk you through some basic elements of this case. We're going to use the document for just a minute to get a handle on what happened, and then let's have a discussion about the ideological divide between the conservatives and talk about this from a more philosophical approach to what this law is. And then we're going to close with one of the last paragraphs of Thomas's dissent, which I think really hits some points home that are pretty important to us here on this channel. And speaking of this channel, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit that like button, hit subscribe. Make sure you turn on your notifications, and if you like this, share the video so other people get to see it as well. All right, so let's take a look. Here's one of the headlines. This is from Fox News, right? Barrett, Gorsuch, Kavanaugh side with liberal Supreme Court justices in computer fraud case. Barrett warned government reading of law could criminalize conduct like embellishing an online dating profile. Very ominous, right? Very ominous. But while we're here, let's go ahead and take a look at what actually happened in this case, because that's going to kick off our philosophical discussion about this law, about what's going on in this case, and about what the decision maybe should be or what needs to happen now. All right, so former Georgia police sergeant Nathan Van Buren used his patrol car computer to access a law enforcement database to retrieve information about a particular license plate number in exchange for money. Although Van Buren used his own valid credentials to perform the search, his conduct violated department policy against obtaining database information for non-law enforcement purposes, as it should. As it should. This is right out the gate. We've got a government agent accessing a database, absent a legal purpose to do so, to get information in exchange for money from someone who doesn't have access to the information. I can think of so many problems with this. But okay, here we go. Unbeknownst to Van Buren, his actions were part of an FBI sting operation. Van Buren was charged with a felony violation of the Computer Fraud and Abuse Act of 1986, which subjects to criminal liability anyone who intentionally accesses a computer without authorization or exceeds authorized access. The term exceeds authorized access is defined to mean to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled to so obtain or alter. A jury convicted Van Buren and the district court sentenced him to 18 months in prison. Van Buren appealed to the 11th Circuit, arguing that the exceeds authorized access clause applies only to those who obtain information to which their computer access does not extend, not to those who misuse access that they otherwise have. Now, Now we get the opportunity to philosophically look at what actually happened, why this conduct might be criminalized, and then talk about the split. So here's the idea. I go up, I don't have access to a database. I say, my friend's a cop, right? I give him $200 and he can look up the license plate of someone I know the name of online, for example. If I do that, I'm then gaining access to a government database for an improper purpose through a proxy. I'm having someone act as my agent to go ahead and get into this database, to get this information that I should not have access to because I don't have it. I'm not in law enforcement. So this guy's accepting money to look up information that is in a government database about someone without a lawful purpose. In fact, I would argue with an explicitly unlawful purpose. But that being said, that's what he's done. He has violated this statute. And I don't think he just violated the statute. I think he actually violated the spirit of the statute. He has gone in to do this. He has gained access to something through his existing credentials, and he has done this unlawful and I think objectively bad thing. I don't think this is something we want police officers doing. Not only is it illegal, but it's against the police department policy. But that's what the statute is designed to entail. It's designed to cover this abuse of government authority to gain access to information that you shouldn't have access to. This is a Fourth Amendment protection for the person who has a license plate, right? Like, this is protecting them from an unlawful look into their stuff through the government. That's kind of a big deal. It's kind of a big deal, and it's being shuffled under the rug. But we've got two competing sides to this sort of analysis, to the analysis of this case. And remember, this entire case turns on this phrase, exceeding authorized access. And so Van Buren argues, and the majority of the court agrees, that he has authorized access to this database. And therefore, even though he used it improperly, and he used it in a way that exceeds his authority to do so, that he still has authorized access, so he didn't exceed his authority. And that's where the split comes down. Amy Coney Barrett, Kavanaugh, Gorsuch side with the three liberal justices. We got Roberts, Alito, and Thomas on the other side saying, look, the plain meaning of the statute says he exceeded his access. Did he exceed his access? Yes, he did not have the conditional requirement of a lawful purpose. He did not have the lawful purpose necessary to look into this database. That's the argument. That's the split there. Now, I think from a more philosophical perspective, we've got two things going on. We've got one side of this argument saying this punishment of 18 months in prison seems really harsh for this, and we've got a dangerous possibility of expanding and criminalizing this behavior into these sort of other areas, right? Amy Barrett mentions misleadingly updating an online dating profile or accessing Facebook or sports scores or something like that. Thomas, on the other hand, is looking at this like, well, we've got someone exceeding their authority to do so. We've got a statute that says you can't exceed your authority and access this database. And therefore, we've got criminal punishments in here. Now, the majority focuses on how this is a felony, but it's not always a felony to do this. It's typically a misdemeanor. There have to be aggravating factors to make it into a felony. And that's something that Thomas focuses on a little bit later in his dissent. And we're going to read that. Maybe right now is a good time to actually read this paragraph, because I think it highlights some of the philosophical things at issue in this case. So let's take a look. The majority's argument also proves too much. Much of the federal code criminalizes common activity. So this is going directly to Amy Coney Barrett's point that some of this law could scoop up other activity. Now, he disagrees that something like checking a Facebook profile would end up being criminalized. He thinks that goes too far. But he's also making this point that even if it did do that, let's see. Absent aggravating factors, the penalty for violating this act is a misdemeanor. This act thus penalizes Minoran offenders about as harshly as a federal law punishes a person who removes a single grain of sand from the National Mall, breaks a lamp in a government building, or permits a horse to eat grass on federal land. So he's saying that even if it does scoop up this otherwise tiny amount of conduct, the penalty is the same as other laws that already punish minimal conduct. The number of federal laws and regulations that trigger criminal penalties may be as high as several 100,000. It is understandable to be uncomfortable with so much conduct being criminalized, but that discomfort does not give us authority to alter statutes. And this is, of course, where we run into some major philosophical questions that the court is saying that they're not equipped to handle. It's Congress. Congress is passing all of these laws. That's what I'm talking about on questions about this channel. On this channel, I always ask, does this law need to be in place? Should this law be enforced with a bullet? Because all laws end at the point of a gun eventually. All of these things are valid questions, and I think Amy Coney Barrett and the other conservatives, and probably the liberal justices as well, are trying to curb the idea that this law criminalizes so much behavior. But that's the Congress we've elected. We've elected a Congress that is perpetually criminalizing otherwise innocuous behavior. This case isn't otherwise innocuous, though. To me, this is a terrible test case. I do not want government agents improperly exceeding their authority to access government databases to go ahead and grab information about private citizens for money. I like, this is beyond, like, why everybody is focusing on the idea that this somehow would criminalize the use of an online dating profile or something like that. I would find that a hard interpretation to follow. What I do not find a hard interpretation to follow is one that criminalizes a police officer who accesses a database for an improper purpose to gain information about a private citizen. Like, that, to me, is a clear-cut sort of use of this law. It is exactly what it is designed to do. Now, Thomas's dissent is pretty interesting. Going through the whole thing would take a while, but it basically boils down to, we have lots of common law issues here. We have lots of property issues here that are commonly established principles of law that would cover this and include his reading of the statute. Of course, Amy Coney Barrett goes to great length and does a lot of great writing to talk about why this is not the proper read of the statute and that it should be limited specifically to systems in which one does not have existing access. Whatever the right answer is, the important thing is not focusing on the liberal conservative split or the split of the conservative justices to join the liberal side and try, like, playing politics with this decision is a silly one. This is a question over what originalism is. And this might actually be a knock to someone like Amy Coney Barrett's originalist credentials. In 1986, when they amended this law, what did they mean when they wrote the statute? I actually fall on Thomas's side on this, which may not be surprising to people. I think Thomas is a fantastic justice. Even though philosophically, I agree with Amy Coney Barrett's criticisms of this potentially sweeping up otherwise innocuous activity, I don't think this is innocuous in its context. And I think what this guy did absolutely violated the statute and the spirit of the statute. And so I find this ruling to be a little bit baffling, personally. Like I said, I fall down on Thomas's reasoning here, but I'd love to know what you guys think about this. Is this the right decision? Is this the wrong decision? Should cops be allowed to exceed the purpose for which they have access to a database? Like, is that okay? Do we want government agents exceeding their authority to access a database not to be penalized for their conduct? I don't. I don't want them to ever exceed their authority in accessing a database about me or you. But let me know what you think. Until next time, peace. Peace.